And live.
Hello, everybody. I am Melissa Muscatine, co-owner of Politics and Prose, and welcome to PNP Live on behalf of my husband and co-owner, who's hidden but near me, Brad Graham, and our incredible events and marketing team. We're so happy to have you join us for tonight's event. I think most of you know that PNP is now sadly not open to the public due to COVID-19, but we are trying to do as much as we can online. Several weeks ago, we launched PNP Live, and we're so thrilled to be able to bring authors like Richard Lazarus to you for discussions of their new books on this new live stream platform. Just a few housekeeping things before we get started. At any time during the event, you can click on the green button that you should see at the bottom of your screen to purchase Richard's book on PNP's website. If you do so, you will get free media mail shipping. And please know that your online purchases are so critical to helping us maintain the staffing and infrastructure required to provide tonight's event and all of our new and much more beefed up web-based programming. We really appreciate the purchases that you make. Tonight, you can also ask Richard a question by clicking on an Ask a Question button that you should also see near the bottom of your screen. This will enable you to read other people's questions as well as posing your own, and you can also vote for questions that you'd most like to have Richard answer. And one last reminder, unlike our in-person events, the author, host, and audience cannot be seen tonight. When we can be seen, you cannot be seen. So if you're having a bad hair day or you have bags under your eyes, do not worry. Nobody is looking at you. I'm going to start off by saying that tonight's event has very, very special meaning for me and Brad, not only because the topic, environmental law and politics, is such an urgent one, but because Richard Lazarus is one of our dearest and most cherished friends. I'm sure some of you in the audience know Richard too. You may have been a student or colleague of his at Georgetown Law School, where he taught for many years, or at Harvard Law School, where he currently teaches environmental law, natural resources law, Supreme Court advocacy, and torts. And this is also really important and worth mentioning, where he's won university-wide recognition for his scholarship and for the extraordinary devotion and attention he gives to his students. Tonight, Richard is going to talk about his new book, The Rule of Five, Making Climate History at the Supreme Court. And I'm saying this as an unbiased person, as if I didn't even know him. But the truth is, it is a seminal work. It's an examination of a single case in the Supreme Court and its consequential impact on environmental law, politics, and advocacy, and what that means for the future of our planet. Now, lest you think that a work by a leading academic might be densely written and hard to penetrate, fear not. Richard, and those of you who know him know this, I'm sure very well. He's a master storyteller with an acute understanding of how law and politics intersect, and his narrative explains the extraordinary characters and chain of events described with wonderful behind-the-scenes detail that led to the case known as Massachusetts versus United States Environmental Protection Agency. And I know this is going to sound weird about a book that's, about a Supreme Court case, but honestly, the book is a page turner. Lastly, it's important to mention that Richard is not just an expert on environmental law, but also on the Supreme Court. He founded and directed the Supreme Court Institute at Georgetown Law. He's frequently quoted in news stories about Supreme Court decisions, and he co-teaches with Chief Justice John Roberts a summer course for students overseas examining the Supreme Court in history. You will have to read Richard's book to find out which side the Chief Justice landed on in Massachusetts versus EPA. I don't want to do any spoilers. And then lastly, Richard has also appeared many times in the court itself, having represented the United States, state and local governments, and environmental groups in 40 Supreme Court cases, and he has presented oral argument in 14 of those. So no slouch, this guy. Richie, thank you so much for doing this with us. We're so honored to host you, and I will now turn it over to you.
Great, thanks so much. I'm really delighted to be able to participate in this live streaming event hosted by Politics and Prose. And I want to thank Alyssa and Brad for this opportunity, as well as the amazing PNP staff for all their help in the event. Bookstores like Politics and Prose, we all know, they're enormously important, and now more than ever. They deserve our admiration, and they deserve our support. So as Alyssa mentioned, I'm here to talk about a recently published book. of mine, The Rule of Five, Making Climate History at the U.S. Supreme Court. My talk is divided in 3 parts, and then I'm really looking forward to the Q&A afterwards. The first part is going to be describing the arc of the story and my overall goal in writing the book. Then next, I want second to highlight parts of the book's story. I want to provide you with a sense of the book's voice, what makes the story so engaging and indeed thrilling at times, and some of the surprising parts. But sorry, just like Lissa, no spoilers. You have to read the book. Then I want to close before the Q&A by describing an unanticipated challenge I had in writing the book and how I addressed it. Now, first, the story's arc and its primary objective. The book is divided into, as you can see, the PowerPoint 20 chapters, followed by an epilogue. The story's arc literally begins with a guy named Joe. And no, it's not Joe Exotic from Netflix Tiger King. The Joe of this story is far more important than that other Joe. And the story ends with a Supreme Court ruling that made history. The most important environmental law case ever decided by the Supreme Court, Massachusetts versus EPA, often referred to as environmental law's Brown v. Board of Education, a case that not only transformed climate change law, but has had worldwide impacts. Now, my primary objective in writing this book was twofold. First, I really wanted to write a book for a popular audience that revealed what makes Supreme Court advocacy so challenging, so fascinating, and I wanted to write it from both sides of the lectern. The obvious side, where the advocate stands to argue before the justices, but also the less obvious side, the other side of the lectern, the advocacy within the court itself. I want to open a window to let the general public see inside the extraordinary amount of strategy, maneuvering, and conflict, the personal and professional drama in Supreme Court advocacy on both sides of that lectern, and the drama and the conflict that happens not from bad motive, but just because the stakes are so high at the Supreme Court. I also wanted to write a book for a general audience that revealed what has made it so difficult for our country to address climate change, why it is proven so hard, often for reasons most people don't appreciate. And for that same reason, why this case is so important. There's no more important environmental issue facing the United States, indeed the world, than climate change. The coronavirus underscores there's no escaping the need for global cooperation for these kinds of global threats. Now, I began researching the book in 2015, completed the research, most of it in 2016, and then I wrote the book in 2018 and 2019. I had to take 2017 off because actually I had my own Supreme Court case that I had to brief and argue before the court. But I approached the research the way I would a Supreme Court brief, scorched earth research. I interviewed everybody, the Clinton administration officials, the George W. Bush administration officials, career people as well as political appointees, the lawyers on both sides of the cases, the clients on both sides of the cases when they were sort of a real client, not just the United States, and the judges and justices involved in the case. And when I had permission, the law clerks too. My one limitation is, as a law professor, I would not talk to a law clerk unless the justice or judge would give me permission first. I also saw, as you can see from this screen, all the underlying documents. I don't just want to rely on interviews and people's memories. I end up knowing far more than anyone else ever knew about this case, including the participants, many of whom were then surprised to find out more about the case they knew when they read the book. I had made public record requests of federal government and state government, but I also received from participants on a voluntary basis boxes and boxes of documents and jump drives, all the email traffic involved, all the drafts, briefs, the meetings, the notes on meetings. I think actually some people are a little unhappy that I have all that I have, but I can tell you it proved absolutely necessary to write such a fun story. All right, so here are some highlights from the book, just illustrative parts of the story to give you a sense of it. Beginning, of course, with chapter 1, the opening scene. It's October 20, 1999. After a year delay, Joe Mendelson walks from his Capitol office down to EPA and hand delivers a petition, the Environmental Protection Agency, demanding that the Clinton Environmental Protection Agency regulate greenhouse gas emissions from motor vehicles, new motor vehicles. At that point, Joe was just fed up. He's fed up with the lack of action by the Clinton administration on climate. They had been there year after year after year. They're about to enter their final year, and they had done nothing to restrict greenhouse gas emissions, notwithstanding the compelling scientific evidence, and notwithstanding the fact the vice president was none other than Al Gore, who had written the book on climate change in 1992, Earth in the Balance, saying this was one of the most important existential threats humankind face and not something anyone could compromise politically about. But the Clinton administration, including Gore, had done just that. So who was Joe Mendelson? He was a young public interest lawyer working for an organization no one had heard of, the Center for Technology Assessment. Had a total of 5 employees, some full-time, a lot part-time. They worked paycheck to paycheck and quite often no paycheck at all. They had small offices on Capitol Hill, and actually right before Joe filed his petition, they had been evicted from those offices for violating local zoning ordinances. And Joe worked very much alone. He worked on the petition late at night by his daughter's by a small light. None of the powerful national groups, Natural Resources Defense Council, Sierra Club, Earth Justice, none of them supported his effort. In fact, some of them actively opposed his effort. They thought it was a bad idea to challenge the Clinton administration. They even tried at one point to cut off his funding to stop him. And Joe didn't have a lot of funding to rely upon. But Joe refused to bend, and he filed his petition anyway, demanding that EPA act. His view was, look, you're not my bosses. You didn't hire me after law school. I don't have your resources. I don't have your fancy stuff. And you can't tell me what to do. I'm not into conciliation acquiescence. But he was under such pressure, it actually took him a year to decide to file. He finished petition in October 1988, and because of the pressure, it wasn't until October 1999 that he just boiled over, just too frustrated. He finally pulled the trigger. That October day, he walked down to EPA and he hand-filed it, hand-delivered it. And for good measure, he mailed a copy to Al Gore and the White House. The petition he filed made its way to the docket room at EPA, where it was formally received. Received there by a docket clerk named Jamie Poole. Ms. Poole did her job. She signed it, she stamped it, she put it in a metal cart, which was rolled down the hallway to the general counsel's office of the agency. No one then imagined that 8 years later, that petition would arrive in the United States Supreme Court. There was nothing easy or smooth, however, about that path to the court. By the time Joe's case reached the court, he was no longer alone. There were hundreds of lawyers on his side, from about a dozen states and more than 2 dozen of the nation's leading environmental organizations and some public health organizations. They called themselves the carbon dioxide warriors. But when they lost that first round of the courts, all but one of those hundreds of lawyers thought that should be the end of the case. Only one attorney, Jim Milkey from the state of Massachusetts, thought that they should seek further review, including Supreme Court review. All the others thought it was a terrible idea, that he would risk a major loss in the court, which would be a huge setback to the environmental movement. They put enormous pressure on him. He received calls which said, if you do this, the future of the environmental movement is on your head because of the risks you're taking. But ultimately, no one had the power to stop him or to stop Massachusetts. So Milkey filed, and they all joined him, not because they believed in his effort, but partly because they wanted to control what he argued. Chapter 12 of the book takes us to another important part of the story. It's called The Lure of the Lectern. It concerns the battle for who should present oral argument before the Supreme Court. Now, there was an easy part. All those 100 lawyers agreed the person who should argue is the best person on the team. They should present the oral argument. But as happens, then vehement disagreement about who that was. Ultimately, the states favored one person, Jim Milkey from Massachusetts, who had insisted on bringing the case to the court, who was the formal counsel of record for all the parties. The environmental groups, though, who had worked on this issue for years and felt very strongly about it, they favored another candidate. It was a good faith disagreement. They were both strong candidates. And it's not that unusual in the Supreme Court to have this kind of conflict, because the Supreme Court, unlike lower courts, only allows one. Even if there are multiple parties, here there are almost like 36 or so parties before the court. The court says, we don't care. One person presents argument. And it's not surprising the conflict happens because the stakes are high, the emotions are high, and the competing egos and ambitions are no small matter. In this instance, though, the oral argument conflict became extraordinarily destructive. I've seen lots of these fights over oral argument when only one lawyer can bring it and there are multiple parties. It happens all the time. But I've never witnessed an occasion where it was so intense. Indeed, it was so intense in this case that 13 years later, 2020, and this dispute was in October of 2006. So 13 years and a few months later, still, the people on that case, on the same team, there's still many of them not speaking to each other. And they were close personal friends and close professional colleagues. Even after it seemingly settled on Jim Milkey for Massachusetts, and that happened in October, the argument happened November 29, 2006. It seemed to settle, but just a few days before the argument, the environmental groups attempted a coup to try to knock Milkey out and bring in their preferred attorney. That's a crazy idea. There's not enough time for anyone to come in then. But its craziness underscores the depth of distrust and the depth of division on the environmental side of the case. Now, the next several chapters of the book describe the oral argument, and they're designed to give the readers a sense of the stunning physical setting of the courtroom. I've got one chapter just called 74 inches, because that's the distance between the lectern the advocate stands before and the bench where the justices sit. Notwithstanding the enormous grandeur of that room, and there's hardly a grander courtroom in the country, perhaps the world, the lectern and the advocate are closer to the judges, the justices, than any other court I've ever seen. It makes it very conversational, notwithstanding the grandeur of the surroundings. And what I describe is the extraordinary give and take between the justices and the advocates, but also the give and take between the justices themselves. Because this is what many people don't understand and realize. The Supreme Court, by tradition, by norm, not by requirement, the justices don't talk to each other about the case and their thinking before the oral argument. For that reason, the oral argument is the first time they all learn what the others think. And the hour they spend at oral argument is the longest time they're ever likely to discuss the case together. That gives the lawyer who's arguing before them quite an opportunity, but also a challenge. It means the lawyer is participating in the justice's first conversation about it. They get to be there. They get to answer the questions. They get to see what the justices are thinking just while the other justices are learning that as well. Now, there are several things a good advocate has to do. The first thing they have to do is decide how to frame the issues, the legal issues, in a way which makes it most likely they'll win. It makes a big difference how you frame a case, how you pitch it, what you make the justices think the case is about, what legal issues. If you do it one way, you may well lose. You do it another way, you actually can win. The lawyer also has to anticipate all the hard questions and develop crisp answers to those questions. If you don't provide an answer to a justice in the first 5 to 7 seconds, they're likely to interrupt you because they assume you don't have a good answer. The norm is the lawyer before the court has to answer 50 to 75 questions in 30 minutes. The justice's questions are the equivalent for a lawyer of trying to hit a Major League Baseball pitch. But at the Supreme Court, you can't steal the signals ahead of time. You don't know what the pitch is going to be. The book describes the oral argument in detail, Milky's back and forth with Justice Scalia, the Chief Justice Roberts. He received 23 questions from Scalia alone. Now, because we have the time, I want to highlight for you 2 points at the oral argument. The first is going to be Jim Milky's opening for the Massachusetts, that all-important opening. And the second is how Milky sought to deal with his primary nemesis on the bench, Justice Anthony Scalia. Now, I want you to listen. There's what Milky said, but listen, because there should be audio you can hear as well. Here's Milky's opening for Massachusetts.
Mr. Chief Justice, and may it please the court, if I may, I'd like to frame the merits very quickly and then turn immediately to standing. Although the case before you arises in an important policy area, it turns on ordinary principles of statutory interpretation and administrative law. EPA made a decision based on 2 grounds, both of which constitute plain errors of law reviewable under any standard. Not asking the court to pass judgment on the science of climate change or to order EPA to set emission standards. We simply want EPA to revisit the rulemaking petition based on permissible considerations.
Now, imagine if you were a climate activist, and that courtroom that day was full of a lot of climate activists. And you had, which they had done, literally slept on the cold sidewalk in front of the Supreme Court overnight in order to get one of the few coveted seats in the courtroom. You probably got there at 5 or 6 the day before in the afternoon, and then stayed there and then slept overnight. Because you wanted to hear one of the biggest environmental law cases ever decided by the Supreme Court on the most pressing issue of the time. You walked in the courtroom, you were there, you were thrilled, and then your champion lawyer stands up, Jim Milky. And this is what he says. He doesn't talk about climate change much at all. He doesn't say, justices, this is the most important pressing issue of our times. The climate science is overwhelming. The nation is headed right to catastrophe. The world is, unless we act. The lawmakers, the judges have to act on this, and they have to do so now. He doesn't say any of that. What he says instead is, well, it arises as an important policy area, but don't focus on that. All you need to do is apply ordinary principles of administrative law. And you don't have to pass judgment on climate science, and you don't have to order EPA to regulate greenhouse gases. All you have to do is ask EPA to visit the rulemaking petition again, based on permissible considerations. I mean, you would think the guy is tanking the case. But what you have to appreciate is the beginning of an oral argument is as carefully crafted, as carefully pitched, every single word, as the beginning of a Broadway play. The Broadway play is looking at its audience and how to engage them, how to get them to basically bring them into the play. In the Supreme Court, there's an audience of 9. Jim Milky, when he stood up there, was not arguing and not giving a speech to climate activists and environmentalists to rally the troops. He wasn't there before Congress in a congressional hearing trying to explain to lawmakers why they needed to pass a law addressing it. And he wasn't running for office and trying to get voters to vote for him. His audience was 9, and he pitched his case to those 9. While it may make climate activists, their hearts go pitter-patter, their passion run deep about climate change, how important it is. For Jim Milky and his audience, the Supreme Court justices, that's not them. Climate change doesn't make their heart go pitter-patter. If he had made an argument, a policy argument about climate change and compelling nature, he knew he would lose this case. So he made the case about administrative law and ordinary principles of administrative law. That's what makes justices' hearts go pitter-patter. That's their bread and butter. That's their life. Yes, that's what they get excited about. So he pitched administrative law, and he made it clear he wasn't asking for very much, just for very little. He wasn't asking to pass on the science. He wasn't asking to order EPA. Just do this one thing. Why? The rule of 5. He wanted to win the case. And to win the case, he had to pitch it in a way that had the best possible chance of getting 5 votes. If they win the case, then they can celebrate. Then they can make it into a big climate case. But he can't give an argument that's a loser. He's doing anyone no favors if he does so. The other part of the argument, which I'm just going to play very quickly, this is Justice Scalia. Just give you a thought, and I want to warn you ahead of time. The audio on this is pretty quiet, and that's why I have all the words there. But if you can hear it, terrific. But you'll have to listen pretty carefully.
I thought that standing requires imminent harm. If you haven't been harmed already, you have to show that harm is imminent. Is this harm imminent? When? I mean, when is the predicted cataclysm?
Right. When is the predicted cataclysm? I mean, Scalia was the master at oral argument. And Scalia wanted to rule against Massachusetts and the environmental groups on what's called Article 3 standing. He wanted to knock them out at the outset. To bring a case in federal court, you have to satisfy Article 3 of the Constitution. It has to be a case or controversy. And the court has said that means you have to have standing, the right kind of injury, to even have a federal court hear your case. And the Supreme Court's test, as Scalia suggests here, is you have to have a concrete and an imminent injury. And the problem is that the kind of assumptions that go into the court's test for the kind of injury required to bring a case really don't fit neatly climate change. Because climate change is about emissions that happen now that have consequences not right now. They have consequences decades from now or 100 years from now. The consequences of climate change occurring now were caused by emissions decades ago or even a century or more ago. So it doesn't fit the test. But if you look at Mielke's argument, and this is the kind of thing the book gets into, he, of course, has anticipated this question, and he's nailing it. He's acknowledging the tension, but he also explaining why it, in fact, fits the standing test of the court. And Mielke knows he cannot afford to lose this case on the standing issue. He doesn't know that he's going to get 5 votes or not. This is the issue. It's the threshold issue. But this is the issue why people said, don't do it, don't take it to the court. Because if you lose on Article 3 standing, if the court rules that we can't bring cases based on climate injury, you have destroyed the ability of environmental groups and the lower courts to bring environmental cases dealing with climate change. Now, the last chapters of the book shift the story from one side of the lectern where the appellate's lawyers argue to the other side of the lectern. Now, this room, the conference room, is literally behind the massive red curtains that are in the courtroom itself. You go out those curtains, you go down below, you go across the hallway, and you end up in the conference room. This is where the justices met on December 1st, 2 days after the argument, December 1st, 2006. This is where they met to basically debate and discuss the case and how they were going to vote. The justices have assigned seats there. They sit by seniority. The Chief Justice sits at one end. The next most senior justice at that point, John Paul Stevens, sits at the other end, and then around the table in order. No one is present in that room when they discuss a case and vote but those 9 justices. No one else there. No law clerks, no assistants, no secretaries. The most junior justice, Alito, his job is to take notes on what they say. And they vote. In this case, the chief went first and went around the room in order with Justice Sam Alito voting last. At the end of that, they had their tentative vote. But it's just a tentative vote. The votes at conference are not binding. There's no binding vote until at least 5 justices agree to join an opinion of the court. But what happens based on that initial non-binding vote is the senior justice in the majority has the responsibility of deciding who's going to write that opinion. Who's going to write the opinion which is going to try to attract those minimum of 5 votes to make it an actual ruling of law by the Supreme Court. And it's a really complicated decision about how to do it. Whether the senior justice assign it to himself or herself, or instead assign it to the justice they think is the most wobbly, the one who might change their mind, because then they're less likely to change their mind because they'll write the opinion in a way that satisfies them. because everyone knows that once the majority starts working on its opinion, that one justice, the dissenting justices are going to try to circulate their opinions in an effort to try to dislodge somebody. Justices change their votes all the time after the conference. They want to see it in writing. They want to see actually how one deals with the issues. And in a closely divided case, it only takes one switch to change the outcome of the case. The book tells the story of how a Jedi master justice, hard at work, how many drafts he took to get that majority, the compromises he had to make, and how the opinion writer, in this case, who ultimately wrote the opinion for the court, made history. Now, I want to mention just a few surprises that no one ever knew before this book comes out, even those deeply involved in the case. One, the role Dick Cheney played at the very beginning, how Cheney's just sheer arrogance at the outset of the Bush administration led to mistakes that affected the outcome in the Supreme Court years later. How and why the Supreme Court even agreed to hear this case. No one, even those who supported Milkey trying to get review, no one, including Milkey, privately thought the court would ever grant review. They hadn't granted review in a circumstance like this for more than 35 years. And when they did that in the early 1970s, they ruled against the environmentalists. And the role played by just a spectacular federal court of appeals judge, David Tatel, in making that happen. And also a surprising role that former Chief Judge Pat Wald played in the case as well. What happened at the Supreme Court itself? How one justice's critical discovery of a century-old Supreme Court case, that none of the hundreds of lawyers who had filed briefs in this case and had worked on briefs, none of them had cited this case to the court. But the justice found it, and it may well have made the difference. Another justice's deft rescue during an oral argument of an attorney who Justice Scalia was seeking to trap, who only Justice Scalia could, and making a potentially fatal concession. And finally, how a bow-tied justice in his late 80s overcame the best efforts of four other justices to secure a majority opinion that made climate history for the United States and indeed for the world. Finally, I promised that I wanted to discuss my unanticipated challenge in writing this book. When I started researching this book in 2015 and writing the book, I thought I knew my ending. I did not then anticipate the results of the 2016 presidential election. Maybe you all did, but I at least was caught off guard. The question then became, well, what to do with it? I knew three things about what I wanted to do. One, I knew I had to acknowledge it and explain its relevance to the story. Two, I also knew I did not want this book to become yet another Trump book or otherwise wed to the latest event of the moment. Why? Because my third goal was to have a story that was meaningful to readers far past the presidency of Donald Trump. For readers years from now, who can enjoy and learn from the thrilling story told, what happens at the court, and what effective, skilled lawyers can do. And I hope that perhaps even years from now, when people are reading this book, some will say, now, who is this Donald Trump guy? So that's the role of the epilogue, to place Trump in perspective and what lessons the book story has for us all in our ongoing struggle to understand and confine the Trump presidency. I'd be delighted to hear and answer your questions.
Thank you, Richard, so much for an absolutely wonderful presentation. And there's so much more in this book, people. You got to read it. He's sort of teased you into the general things, but it's just an incredible story, as I hope you can tell from what Richard has said so far. Okay, so here's a first question. Does the precarious state of Chevron deference almost guarantee a major weakening of this ruling's impact once another case comes before the High Court?
Well, actually, not really. Let me tell you, Chevron is a case decided by the Supreme Court in the sort of mid 1980s, written by John Paul Stevens. It's a case where the Supreme Court ruled that they were governed by the plain meaning of the statutory language. When they review an interpretation of a statute by a federal agency, they have to first look to see whether the statute has a plain meaning. If it does, they have to abide by that meaning. If the meaning of the statute is not plain from the text, but it's ambiguous, they have to defer to the agency's interpretation so long as it's reasonable. In this case, though, they found the meaning plain. They actually ruled that the statute compelled what Joe Mendelson had argued, that greenhouse gases were air pollutants under the plain meaning of the statute. And that reason, they actually refused to defer to EPA. They rejected EPA's interpretation here. There's no reason to think they would interpret this any differently now. The conservative justices on the court, they're textualists. They believe in plain meaning. They don't like deferring to agencies. I actually like, in many contexts, deferring to federal agencies when the statutory language is ambiguous. But in Massachusetts versus EPA, it's not. It wasn't ambiguous then. It's not ambiguous now. And I see no reason to assume that the current justices on the court, who believe in textualism even more than before, would revisit the question whether greenhouse gases are air pollutants under the Clean Air Act. I don't think they will.
Second question, I'm going to paraphrase slightly. My question is to the politicization in current legal rulings. I think the person means, as legal argument is now in some instances secondary to politics. Your thoughts on this concern?
Yeah, I mean, I do worry about the tendency for the Supreme Court to be more politicized. I think the court tries very hard to avoid that tendency. It's hard to do when candidates for the presidency, like Donald Trump in 2016, actually run on a platform where they list the candidates who they would actually nominate to the court. So you're supposed to vote based on that list. And it's hard to do when members of Congress obviously politicize it. But the one point I want to make is obviously politics matters, and it clearly matters at the Supreme Court, but not as much as everyone assumes. And I never go into a case assuming that someone who is nominated by a conservative president, Republican president, will vote against me when I represent environmentalists, and a liberal will vote for me, appointed by a Democratic president. The justices are more complicated than that. Law is more complicated than that. And that's why framing a case and pitching a case are so important. You pitch it in a way that tries to get their vote. You don't pitch it as political. You don't pitch it as a question of, are you liberal or conservative? Do you believe in climate change or not? There's a legal issue in the case. And you appeal to the justice in a way that gets their vote. And we do that all the time in the Supreme Court. I've had several cases. I had a big case involving hazardous waste disposal in the city of Chicago. I pitched it as a strong plain meaning case, and we won. Who wrote the opinion for me? Justice Antonin Scalia. Who dissented? John Paul Stevens from the city of Chicago. I had a case a few years ago involving retired railway workers who had asbestosis. And the question was whether they could recover for their fear of cancer or not. I pitched the case on plain meaning. I pitched the case in terms of traditional common law and not having judicial activism. And we won. Who wrote the opinion? Ruth Bader Ginsburg. Who joined her opinion? John Paul Stevens and David Souter. Who were our fourth and fifth vote? Clarence Thomas and Antonin Scalia. The court is more complicated. Good advocacy can look at the justices and they can figure out ways to pitch things. The justices are not as sort of automatic votes in cases as one might think. I'm not saying they never are on some issues. There are some things where they tend to be untethered from text and untethered from legal issues. But there's far fewer of those cases than people think. And the good Supreme Court advocates, and there are a lot of great advocates out there, they know this. They know how to frame cases and pitch cases and win cases that people think couldn't possibly be won.
Richard, a bunch of people are interested in this question, which this case clearly the winning argument favored the dry legal approach more than a different kind of approach. Anyway, this question says, For high-stakes political cases, it is always strategic to frame arguments in ways that avoid focus on the political issues, but instead keep to the relevant dry legal arguments. Interesting to consider issues like abortion, the border wall, affirmative action.
Yeah, no, it's absolutely true. You want to approach the case and try to figure out some angle. Well, especially if you think the justices on the more policy point are not sympathetic to you. If you think they're sympathetic to you, then you're going to push that. If you think they're not, you're going to turn a different kind of case. You're going to turn to what's called a federal courts case. You're going to turn to an administrative law case. You're going to turn it into a civil procedure case. You're going to turn it into a federalism case. In Massachusetts versus EPA, one thing they did was try to turn it into a federalism case, a case about respect for states and state sovereignty. That's why they had, among other reasons, Jim Milkey argue it. He was from Massachusetts. He was a career attorney with Massachusetts. That's why the name of the case is Massachusetts versus EPA. They deliberately did not make the case, right, Earth Justice versus EPA, because they didn't want the justice to think about this as like an environmental policy case. They want to make them think about it as a state sovereignty case. The same is true in all those other ones. Some issues, you can't always do it, but you try your best. And quite often when I'm in front of the Supreme Court, I often realize I'm not going to win the case. I'm trying to lose it the right way. I'm trying to get what we call in the trade a soft landing. I know often when they take the case and the way it's framed by the lower courts in the record, we're not going to win this case. And I go to my client and I say, we're going to lose this case. But how about we lose it this way? Not the way they're hoping to lose it, this way. Let's try to lose it this way. And the client says, that's fine. I can live with that. And that's what we do. We go there and everything is designed to keep the court away from the big issue and get the court to rule against us on a lit issue. I had a case about 15 years ago in front of the court involving environmental law and regulation of land use restrictions, whether it was unconstitutional, environmental protection, restriction on the use of land. And they took the case. I said to my client, we're losing this case. And I said, how about this way? They said, fine. And we lost it. But Souter wrote the opinion, very narrow drawn, did little damage. Scalia wrote a separate concurring opinion, apoplectic, because they didn't reach the bigger issue. That's what you do. Even if you think you're going to lose, you figure out how you want to lose it and try to lose it in a way that does little damage and you can live again. And there are a lot of really good lawyers out there right now. We've got a very, very active and very skilled Supreme Court bar on all sides of these issues, and they know this.
You start off the book saying you're meaning to be hopeful and inspiring, and it is a hopeful and inspiring story. And then the epilogue, which has to do with the current situation and the sort of withdrawal from Paris and everything else, you kind of issue a call to action saying, it's not one Supreme Court case does not define generations and movements, just like Brown v. Board didn't. And here's a question that sort of gets to that. What are your thoughts on more recent pieces of climate litigation currently percolating through the courts? Oh, sorry, this is a different question. Well, I'll get to the other one in a minute. For example, the state law nuisance cases currently pending across the country.
Yeah, the state law nuisance cases, what's happening right now is a lot of cities around the United States are challenging the energy industry, and they're trying to use sort of common law nuisance. A nuisance is a doctrine of tort law, which basically says you can't unreasonably injure rights common to the public, and that could be air pollution, water pollution. And people are trying to basically bring nuisance actions on climate injury, states and local governments, very similar, at least in theory, to the very successful tobacco litigation of a couple decades ago. I think some of those theories may well have some merit. There's some force to it. They may well achieve some success along the way. They're harder cases than Massachusetts versus EPA. It's going to take a lot of legwork, a lot of building of factual records to actually persuade lower court judges to rule in that way. But they have some promise. I wouldn't dismiss them altogether. But it's a rough path.
So here's the question that I meant to ask, but I'm actually now going to combine it with another question because they're sort of similar. It sometimes feels like there's a finality to Supreme Court decisions when it comes to policy, but are you optimistic that the Supreme Court and litigation in general could actually drive climate policy forward? That's one question. And a related question, are you optimistic or pessimistic over the long haul about the climate and the role government will have in regulating the climate's future?
Yeah, I mean, I've been involved in environmental litigation for a long time, and there's one thing any environmental litigator knows, whatever court they're appearing before, and then every victory, no matter how large, you can't get much larger than the Supreme Court. And this case was just an absolute trigger for an enormous amount of very positive lawmaking. But every win you have in environmental law is provisional. You're always going against very powerful political forces and economic forces. Because those who favor environmental protection, the real beneficiaries are future generations. And you have environmental laws tend to challenge the here and now for the benefit of the there and then. And that means every time you win a big case, the powerful political forces, the here and now, they don't go away. They regroup. They regroup to fight again. So every win is provisional. You have to keep being in there. You have to keep fighting. It's like whack-a-mole. And the same thing was true here. Enormous amount was achieved during the Obama administration based on mass versus EPA. But then a new election happened in 2016. And that election is threatening a lot of that. It hasn't succeeded. But the lesson is, if you want really transformative change, and Lisa mentioned Brown v. Board of Education, you want truly transformative change in this country, it takes more than 5 votes of Supreme Court justices. Mm-hmm. Those votes make a huge difference, like Brown did, and like Mass versus EPA did. But Brown v. Board of Education did not eliminate racism in the United States. It did not segregate schools across the country in the United States. We still have a lot of the major problems we had back in the 1950s. It triggered very important legislation, the Civil Rights Acts, by Congress several times. It actually promoted a cultural change and a shift in the country as well. The same is true for climate change. But my point is that a vote like in the Supreme Court is absolutely necessary. It can be transformative, but only if it's then coupled with more long-term actions by legislatures and executive branch agencies. It takes more than the votes of 5 Supreme Court justices to do that. If you want to make history, you've got to fight for it. One of my unfavorite arguments of all time, my students know this, is people argue the other side, their opponents, are on the wrong side of history, assuming that history, the way they want it to be, is preordained, that it will naturally happen. That's a huge, colossal mistake. You fight for history. If you want something to happen, you can't be passive. You have to fight for it. And you can't just rely on the justices or courts to do it. They can help lead the way, but then you have to take action yourself. It takes elections in the United States to really have long-term transformative change. It requires people electing to the White House, electing to Congress, electing to governors, electing to state legislatures, people who are truly committed to the climate issue and to this long term. Court decisions are important. In this case, they can be critically important, but they're not everything. It takes the votes of individuals. It takes individual votes of people, just like Joe Mendelson in this case. He made this case. It never would have happened. But so do individual voters around the country. If you want to address the climate issue, go out and vote. Don't assume history will come your way without it.
Richard, I believe there is a lawyer in your book who, if I recall correctly, in the Bush administration, who was a Federalist Society trained lawyer. And this question asks, does the Federalist Society play a role in putting justices on the court who oppose environmental regulation?
You know, that's a pretty hard one to answer. I mean, the Federalist Society, I think they play an outsized role, especially in the current administration. I don't think any outsized organization has ever played this kind of disproportionately influential role where the White House and the president is sort of turned over to the Federalist Society, the job of identifying who they should nominate to the Supreme Court lower courts. That is simply, as far as you know, unprecedented and quite troubling. But I don't think the Federalist Society is like an anti-environmental organization at all. I know plenty of members of that society who believe in strong environmental protection laws. They're not as sort of homogeneous as one might assume. They believe in a certain way to make law, a certain way to read statutes and regulations. But I don't view anyone anyone recommended by the Federal Society as sort of anti-environmentalists or lost cause for that reason. I might prefer a more liberal, progressive person. I certainly would on the Supreme Court or in a lower court. But what advocates do is we work with what we got, and you can find a way to appeal to them too.
Next question is very straightforward. What do you think the legal fate of the Clean Power Plan will be?
Well, the Clean Power Plan is a plan put out under the Obama administration, actually very much based on Mass versus EPA, an extraordinarily ambitious plan which sought to reduce greenhouse gas emissions from the single biggest source in the United States, and that's the nation's power plants producing electricity. It was just a fabulous rule put out by Gina McCarthy at EPA during the end of the Clinton administration, October 2015. A rule made possible by Mass versus EPA, and a rule that made possible the historic climate agreement in Paris, just about a month and a half later in December of 2015. That rule, the Clean Power Plan, as the questioner alludes, was challenged in court by industry. And at that point, EPA defended it, as did the same lawyers and the same parties involved in Mass versus EPA. We were actually in the midst of that litigation. I actually was a lawyer in that litigation in front of the DC Circuit. I was pretty confident we were going to win that case after oral argument in the DC Circuit en banc before all the judges. But that process was circumvented, truncated, disrupted by the election of Donald Trump in 2016. They have since repealed the Clean Power Plan. They've replaced it with a far weaker plan to regulate greenhouse gases. The Clean Power Plan was really just a brilliant, pragmatic, pretty moderate plan in what it required, but really far-reaching in how it would help address the climate issue. But we don't really know what would have happened in the litigation. I'm hopeful we have a new administration. We'll lose the Trump plan. We'll get back the Clean Power Plan, and we'll litigate it. Here's what I will freely acknowledge, and I think the questioner knows this as well. The Supreme Court today is more conservative than it was when we litigated the Clean Power Plan in September 2016. The replacement on the court of Justice Kennedy for Justice Kavanaugh will make it harder to win the Clean Power Plan case. The Clean Power Plan, it's a fabulous plan, a matter of policy. It's stretching things a little bit on the law. It's not a slam dunk win. I think it's legal and valid, but I would be first to acknowledge that it's not as though it's not a tough legal argument. I'm less confident with Justice Kavanaugh on the court than I was with Justice Kennedy on the court. But that just means the new EPA, if there's a new administration that comes in next year, they know that. And they'll figure out a way, and we already started talking about it. There are ways to reframe the Clean Power Plan and how you pitch the Clean Power Plan and how you argue for a plan that achieves just about what the Clean Power Plan does, which doesn't raise the same red flag for a justice like Kavanaugh or a justice like Gorsuch before. So the Clean Power Plan would be in worse shape under this court than before, but we can recraft it, and there are people already hard at work on it right now.
I don't think we want to have you answer what happens if there isn't a new administration. So I'm just going to move on to the next question, which is actually a really interesting sort of process question. And it's, are there any statistics on what makes justices change their minds? Some say that oral argument doesn't actually do much. Would you say the private conferences and the circulation of the majority and dissenting opinions is the most influential? Yeah,
I would put a little more weight on the oral argument than some people do, but certainly the circulation of opinions. It's one thing to read other people's briefs and come to a conclusion, but what the justices know is sometimes it doesn't write. There's a discipline to writing, a requirement of actually engaging all the arguments and trying to see how you can answer it. There's a discipline that actually makes people rethink things. That's why it's so good the justices actually produce their opinions in writing. So votes change not at all infrequently during the opinion writing process, not during the conference itself. The conference itself, there's not really very meaningful deliberations at all. it's in the circulation of the opinions and competing opinions that you see people become much more rigorous and deep and thoughtful about it. But to give a nod to oral argument makes a difference. Sometimes I've quite often seen justices come in and they just have a misconception about the case. They just come in just not quite yet having grasped it. And you see the light bulbs go off. Sometimes it's because you have a fabulous Supreme Court advocate. But quite often, it's not just the advocate before the court. Remember I mentioned before, it's the justices themselves. The justices learn from each other. They learn the points and arguments and the weaknesses of arguments by the advocates from the justices. And they spend an hour doing it. So you certainly see people change their mind often. And let me point something out. It's not always whether they change their mind or whether the judgment below the lower court will be reversed or affirmed. That's, of course, important. But it's often they change their mind in what the opinion will say, and what issues it will address, what issues it won't address, and whether they have a broad opinion or a narrow opinion. In the United States Supreme Court, it's not really all about the sort of judgment, affirmed or reversed. It's how narrow or broad the opinion is, because that will determine the precedential effect of the case in a widespread fashion over decades. And on those issues, on how broad or narrow the opinion, that changes a lot. It changes based on the argument, and it changes based on the opinion writing, even if the judgment doesn't change.
Mm-hmm. Richard, we have time for two final questions, and they're sort of a little bit related. The first one is, how successful were your FOIA requests? I've done similar research and have been rather disappointed by the lengthy delays and obfuscation by some agencies, not the ones relevant to your book.
Yeah, I would say I was disappointed too. Almost everything I got was really voluntary from people. I got some stuff from the FOIA requests, but I was pretty annoyed because actually I made the FOIA requests during the Obama administration. I was very careful to make them before the November election. And I thought, and some of the people there were people who were very sympathetic to Massachusetts versus EPA, and they had discretion to turn a lot of stuff over. It wasn't required that they not turn it over. They weren't mandated to do it, but they had discretion to turn over a lot of the stuff. They didn't turn over nearly the amount of stuff that they should have turned over to me. But notwithstanding that, I got stuff. I got a lot of stuff, but I would have liked to get more.
And here's the final question. How did you gain insight into the discussions within the court's conference? Justices typically don't discuss what goes on there. Did you access records from retired justices?
Well, I'm not going to answer the last question about whether I got access from retired justices, because that would make it too obvious who I talked to or didn't talk to. I did talk to justices. I talked to one justice on the record, John Paul Stevens. I spent time down in Fort Lauderdale with him. It was a highlight of my time. I was actually scheduled to have one more meeting with him to read him the final chapter, and he died a week before we were supposed to meet. Just an incredibly classy, wonderful person. And then I talked to some other justices, sort of off the record, on background, but enough that I could report their information, but not for attribution. So I got a pretty good sense of what was going on. Even one justice I was talking to, that justice even pulled out the file on the case and started reading it in front of me. So I had a pretty good sense of what happened in the case, but not from any justice ever turning documents over to me. That they're not going to do.
So, Richard, I lied. There turns out to be one other question that looks interesting that I think would enjoy, and it should be easy. What is something about the Supreme Court that most people would find surprising, but that ultimately is key to its function?
I think most people would be surprised by the fact that justices change their vote so often during the opinion writing process. I think people would be very surprised to know what a difference it makes who gets the opinion assignment and how skillful that person is. Some people aren't very good at it, and they lose their majorities. They overreach, and a case that went one way goes the other way. Others are really, really good at it. The name of the book is The Rule of Five. That's actually in honor and celebration of Justice William Brennan. He was on the Supreme Court appointed by Eisenhower. He later regretted the appointment because he tried to be more liberal. He was on the court in the 50s, 60s, 70s, through most of the 80s. And actually early 90s, replaced by David Souter. And Justice Brennan famously used to bring his law clerks in the first day. They'd all be there, and he'd say, all right, what is the most important rule of federal constitutional law? And these law clerks are recent graduates of Harvard, Yale, Stanford, Columbia, whatever. And let me tell you, they're very smart. And the only thing they might not be is as smart as they think they are. They're very self-impressed. They've graduated top of their classes. They're at the U.S. Supreme Court. So they quickly would always debate among each other to impress Brennan. Say, I think it's the First Amendment. I think it's, the Fifth Amendment. I think it's equal protection. I think the 14th. And Brennan would always say, you're all wrong. The most important rule of federal constitutional law is the rule of 5. It takes 5 justices to have a ruling. And Brennan was known as the master of the rule of 5.
Okay, so we unfortunately have come to almost to the end. We like to end these with the host, that would be me, asking a final question, which is a surprise question for you, which is, what are you reading now?
Oh,
you read that you like.
Actually, it's very funny. I'm reading a controversial book right now, and I'm reading it partly because it's controversial. America Dirt.
Okay.
Caught my eye. Yeah, it caught my eye because of the controversy around it. And I thought, well, this would be really interesting. And it's a pretty moving book. I'm about, I would say, a third of the way through.
Don't say anything more, or you have no idea what you could end up happening.
Right.
So,
but it's a gripping story.
Yeah,
and not almost as gripping as the rule of 5.
Yeah, almost, right. Richard, thank you so much. Thank you to our audience. We had a huge crowd tonight for Richard and for his incredible book. Thank you all for coming out. I just want to say one more time how grateful we are to you for your patronage. We really cannot continue to host these kinds of events without your support and without the book sales we need to be able to put these events on. So I remind you once again that you have a purchase the rule of 5 button at the bottom of your screen in a little green box. And I should also point out, Richard and I were talking about this before, that because we're all trying to be physically separate from one another, even in sometimes in the same household, you don't want to fight over Richard's book. You might want to consider buying multiple copies for your household just to be safe. You can also follow our event schedule and be reminded of our events by clicking on the little follow button up in the green on the upper part of your screen. And we hope that you all stay healthy, stay safe, stay well, and stay well read. So thank you all. And thank you, Richard.
Thank you very much. It was a real pleasure. Thanks.
Loved having you.